All right, so I'm going to okay. Ethics in action.
All right.
Now,
Good.
so in order to go into the actual the video file, am I stopping the slide or no? I'm not stopping the
You
slide.
don't have to.
Okay.
You don't have to. But to go back to the slide, you may have to hit exit slides like the presentation to start it again, and it'll start off in the same spot. So that's not a problem.
All right, perfect. All right, thank you so much.
Yeah, have fun.
If I freak out, I'll call you. So keep your phone open. Keep your phone open. No, don't go to lunch. Don't go to the bathroom. Just if you haven't heard from me in 15 minutes, then you can do your thing.
Okay.
All right. So it looks like nobody's here.
Not yet, anyway. It's just 12 o'clock now, so.
All right. Thank you.
Okay.
Well, good afternoon. Today is a great day. There's sunshine going on outside, and we are in the process of learning about the code of ethics and what happens when people do not follow the code of ethics or are not aware of what they should know. The code of ethics is a detailed document that spells out the professional responsibilities of every realtor. So, what does that mean to you as a real estate professional? It means that you, as well as every other realtor with whom you work, has voluntarily agreed to abide by the code of ethics based on professionalism and protection of the public. Realtors are subject to disciplinary action and sanctions if they violate the duties imposed by the code of ethics. So in this webinar, we're going to talk about our obligation to protect and promote the interest of our clients. The Realtors Code of Ethics starts out with a preamble, and it has three different sections: duties to clients and customers, duties that we have to the public, and duties to other realtors that we work with in a transaction. In this series, we are going to discuss one article at a time in each webinar because I want to make sure that each one of these articles is discussed in detail and you understand not only what the obligations are, but also how to protect yourself and your clients from other agents who are not following what they should be doing under the Code of Ethics. So we're going to start out with the preamble. With the preamble,
under all is the land. Upon its wise utilization and widely Under all is the land. Upon its wise utilization and widely allocated ownership depend the survival and growth of free institutions and of our civilization. Realtors should recognize that the interests of the nation and its citizens require the highest and best use of the land and the widest distribution of land ownership. They require the creation of adequate housing, the building of functioning cities, the development of productive industries and farms, and the preservation of a healthful environment. Such interests impose obligations beyond those of ordinary commerce. They impose grave social responsibility and a patriotic duty to which realtors should dedicate themselves, and for which they should be diligent in preparing themselves. Realtors, therefore, are zealous to maintain and improve the standards of their calling and share with their fellow realtors a common responsibility for its integrity and honor. In recognition and appreciation of their obligations to clients, customers, the public, and each other, realtors continuously strive to become and remain informed on issues affecting real estate, and as knowledgeable professionals, they willingly share the fruit of their experience and study with others. They identify and take steps through enforcement of this code of ethics and by assisting appropriate regulatory bodies to eliminate practices which may damage the public or which might discredit or bring dishonor to the real estate profession. Realtors having direct personal knowledge of conduct that may violate the code of ethics involving misappropriation of client or customer funds or property, willful discrimination, or fraud resulting in substantial economic harm, bring such matters to the attention of the appropriate board or association of realtors. Realizing that cooperation with other real estate professionals promotes the best interests of those who utilize their services, realtors urge exclusive representation of clients. Do not attempt to gain any unfair advantage over their competitors, and they refrain from making unsolicited comments about other practitioners. In instances where their opinion is sought, or where realtors believe that comment is necessary, their opinion is offered in an objective, professional manner, uninfluenced by any personal motivation or potential advantage or gain. The term realtor has come to connote competency, fairness, and high integrity, resulting from adherence to a lofty ideal of moral conduct in business relations. No inducement of profit and no instruction from clients can ever justify departure from this ideal. In the interpretation of this obligation, realtors can take no safer guide than that which has been handed down through the centuries, embodied in the Golden Rule. Whatsoever ye would that others should do to you, do ye even so to them. Accepting this standard as their own, realtors pledge to observe its spirit in all their activities, whether conducted personally, through associates or others, or via technological means, and to conduct their business in accordance with the tenets set forth below.
So what you just heard is the preamble to the Code of Ethics, which is not what determines whether someone has done wrong or should be penalized, but they are lofty ideals that we should all strive to follow. The Code of Ethics has, like I mentioned before, 17 articles. What we're going to be talking about right now is Article 1, which is the article of protecting and promoting your client's interests above your own, and also to be honest with all the parties involved in the transaction. I am going to play now the video for the Code of Ethics, Article 1.
When representing a buyer, seller, landlord, tenant, or other client as an agent, realtors pledge themselves to protect and promote the interests of their client. This obligation to the client is primary, but It does not relieve realtors of their obligation to treat all parties honestly. When serving a buyer, seller, landlord, tenant, or other party in a non-agency capacity, realtors remain obligated to treat all parties honestly.
to keep that information private. Okay? So we have an absolute obligation to disclose that information. In our Standard of Practice 110, realtors shall, consistent with the terms and conditions of the real estate license and their property management agreement. This one deals with property management. We have an obligation and to protect the property, to regard for the right, safety, and health of the tenants, and to make sure that the property is being used for lawful purposes. If we find out that the property, now this is specifically disclosing information about property management situations. The average real estate agent does not deal with property management, but there are particular agents who specialize in property management. So this would apply specifically to them. In Standard of Practice 111, realtors who are employed to maintain or manage a client's property should also exercise due diligence and make reasonable efforts to protect it against reasonably foreseeable contingencies and losses. This has to do with you having a listing and making sure that there is no snow on the property when people are trying to go see it. That if the property is vacant, to keep an eye on it and make sure that it is being protected against vandalism. That if there is a broken step, to let the owner know that there is repairs that need to be done, maybe put signs up so that the property is protected, but also that people visiting the property are not going to be falling or causing an accident that would get the seller to be in trouble and have a problem with an insurance claim. Standard of Practice 112. When entering into listing contracts, realtors must advise the sellers and landlords the realtor's company policies regarding cooperation and the amount of any compensation that is to be offered to anyone involved in that transaction who brings the buyer, whether they are working as sub-agents, which would be agents of realty executives, or anyone who is working specifically as a buyer's agent or as a transaction broker. If there is any potential for agents to be acting as a dual agent, we have an obligation to obtain the informed consent to dual agency up front. Okay? And then Standard of Practice 1.3 is on the buy side. We are required to advise those potential clients, buyers and tenants, the amount of compensation that has to be paid by them. In the case of a rental, for example, in most situations, the tenant pays the commission or the real estate fee for that rental. When it comes to a sale, in most cases, it is the seller who pays that compensation. So we have an obligation to advise them that what is our company policy when it comes to cooperation, as well as the compensation they're responsible for paying, or who's paying the commission. If there's any potential for offsetting compensation, for example, in a rental situation, this happens mostly. The landlord is willing to pay for half of the commission, and the tenant is responsible for paying for the other half of the commission. That has to be disclosed. We also have to obtain informed consent to dual agency from those buyers and tenants ahead of the transaction, and explain to them that some of the properties we may show them or have available to show them, if they are listed with our company, then they fall under the dual agency category, and we need their informed consent to be able to show those properties to them. We also have an obligation, and this one sometimes people forget to be mindful of. The possibility that sellers or sellers' representatives may not treat the existence, terms, or conditions of their offer as confidential, unless that has been either required by law, which is not in New Jersey, or by regulation, or by a confidentiality agreement. For example, you make an offer to purchase and you send it over to the other agent. The other agent is not required to keep that offer confidential. They can actually use that if they choose, with the seller's consent, against the buyer, to obtain other offers. And most people are not aware of that. In Standard of Practice 114, fees for preparing appraisals. Now, this only applies to licensed appraisers if it comes to preparing an appraisal. It cannot be based on the value of the property. So if it's a low price, I'll charge you less money. If it's a higher price, if it's $1 million property, I'll charge you more. That would be a violation of the Code of Ethics. For us as real estate agents, this would apply if somebody asks us to do a broker's price opinion. Again, we are not allowed to charge more money if the price is lower or higher. It has to be a fair price. With Standard of Practice 115, Realtors, in response to inquiries from buyers or cooperating brokers, and here is the key, shall, with the seller's approval. And this is something that I get questions about all the time at the office. Am I required to disclose that there are other offers? So here, this very specifically states that with the seller's approval, disclose the existence of offers on the property. So if the seller does not specifically give you approval to disclose, you are not required to disclose that there are offers on the property. Even if the other agent gets mad, well, you never told me that there were offers. Well, here you represent the seller, not the other agent. But where disclosure is authorized, Realtor shall also disclose if asked. It does not have to be disclosed unless somebody asked you whether the offers were obtained by the listing licensee, by another licensee in the listing firm, in other words, from the same company, or by a cooperating broker. So it is very important when we're taking a listing to have the conversation with the seller. Mr. and Mrs. Seller, when we receive offers, would you like me to keep that information confidential and not disclose to other agents that there are offers? Or do you prefer that I disclose that there are other offers? The seller may ask you, well, what would be better? You need to explain to them that some agents will ask, and unless you get their permission, you are not allowed to disclose it. So if they want to create a little bit of excitement and maybe a little bit more of a quick response from agents to present offers, then disclosing that there are offers coming in or that there are offers on the table may get those agents to hurry up and put in an offer as quickly as possible. But unless that is discussed and agreed upon, confidential information is considered when offers are received. So if the other agent and the seller says, no, don't tell anybody, just let them come in as they come in, and the other agent gets mad because you did not disclose, the best way to protect yourself from any alleged violation is to have that permission in writing from the seller. Okay, so very easily it could be a confirmation by email, by text, and then you just keep that in your records. Standard of Practice 116 states that realtors shall not access or use or permit or enable others to access or use listed or managed property on terms or conditions other than those authorized by the owner or the seller. This was adopted in 2012 when a couple of real estate agents, actually from New Jersey, from our area, were using a property for their own interest without permission from the seller. So in other words, we cannot use for our own purposes a property or allow other people to access the property without permission or for the purpose it was intended. One of those situations might be giving a buyer access to the property without us being there, giving them the code to the lockbox without being there and present, using the property to host a party or get together with a friend, use the pool without permission. Okay? We have authorization to promote the property for sale, not for any other reason. So it is very important to not only, it's not enough to just know the code of ethics and our obligations, but to actually practice what we know. In a couple of case studies I'm going to tell you, I'm going to go over just a couple because I don't want to take too much time. This is an actual case study where there were multiple offers and the listing broker agreed to reduce the commission if the buyer came through them. So Realtor A listed a house for sale, put it on the MLS, and it was advertised. The house was very well priced, and it attracted the attention of a lot of potential buyers. Buyer B made an offer. Buyer X also made an offer. And some of these buyers looked at the property several times. Several offers came in. One of the offers came through the listing agent who had come to an agreement with the seller that if they actually sold the property, they would have a commission lower than if the property was sold through a cooperating broker. Okay, there is nothing illegal or unethical about that, but anything like that has to be disclosed. In the multiple listing service, there is a box that asks, is this a dual commission agreement or arrangement? That is what that means. That means that if I take the listing, Mr. and Mrs. Seller, if someone from a different company has the buyer, the commission is X. But if I sell it myself, the commission will be 1% less than if it's sold by another company. That is what is meant by a dual compensation arrangement. So in this particular situation, several offers came in. one of them from the same agent, and the commission was lower. Okay. How people get in trouble is if they do not do that disclosure. Some of the buyers who did not get the house were very dissatisfied that they did not get the house because they were actually offering more money for the property, but once the commission was deducted, the net to the seller was going to be less. They submitted a complaint to the Realtor organization, and there's a hearing that happens. So the agent has to go and defend their actions in front of a group of peers. If the disclosure has not been made, then there is no violation. But if it has not been made, or if the seller is not informed of what is happening with the offers, then that would definitely be a violation. So it's very, very important to keep the disclosures going and giving the information to the seller, especially when multiple offers are coming in. There's another case I'm going to talk about, which has to do with an agent buying a property for themselves, which they have listed. So when you have listed a property and you become interested in that particular property, you have an obligation first to the seller, not to yourself. In most cases, you should be paying full price for that property, and give the seller the opportunity to either have advice or representation from another party, maybe your manager, your broker, another agent, an attorney, and because when your interests are on the table, it's very difficult to prove that your interest was more on the seller side than on your own interests. Okay, a particular agent purchased the property that they had for sale, offered a lower price than what was advertised, and then soon after that fixed it a little bit and sold it for $80,000 higher than they purchased it. Obviously, that seller felt betrayed because they felt that they were not given the correct information or advice from their agent. And yes, the agent was found guilty and in violation of the Code of Ethics. This also happens when buying a property and not disclosing that you're a licensed real estate agent. Okay? Very, very important to keep that in mind. So with that, I am finishing this presentation. I really appreciate your time with us, and I hope to see you next week, where we will be covering Article 2 of the Code of Ethics and your obligation with that. Thank you and have a great day.